Hi, I'm Emily and I am here with Maya Murphy's attorney, Lauren MacDonald. Attorney MacDonald practices at Maya Murphy's Westport, Connecticut office and is admitted to practice law in both Connecticut and New York. My question today for Attorney MacDonald is, what legal claims can I bring against private schools in Connecticut or New York?
Hi, Emily. Thank you for that question. In private schools, the relationship between the school and the student is contractual in nature. Meanwhile, federal and state statutes, such as the Individuals with Disabilities Education Act, otherwise known as IDEA, and Title IX, govern public schools. As a result, due process and discrimination claims available to public school students are generally unavailable to private school students. However, this does not mean that private schools are immune from civil liability when a student is harmed. Valid legal claims against private schools may include breach of contract, negligence, and fraud. So, as I said, a contractual relationship between a student and the private school in which he or she is enrolled is usually what occurs in the private school context. A contract is a legally binding promise to act or provide products or services, usually in exchange for money or services. In the private school context, a contract may stem from an admission agreement, a student handbook, or even information from a school website or brochure. In exchange for your enrollment and tuition payment, the school is obligated to adhere to the express and implied promises found within these documents. If your school fails to hold up its end of the bargain, it may be liable for breach of contract. A school may also be liable for negligence if it breaches its duty of care, resulting in harm to a student. The duty of care in this context is usually based on the same documents that establish the contractual relationship between the school and the student. These include the admission agreements, handbooks, and brochures. For instance, a provision within a student handbook prohibiting harassment may establish that the school has a duty of care to prevent and/or punish any harassment that may occur. Once the school's duty of care is established, the student must establish that the school breached that duty. For instance, a school's failure to adequately prevent harassment or to appropriately respond to reports of harassment may constitute a breach. To prove negligence, the student must also prove that the breach resulted in harm to the student. In this context, harm may be academic, emotional, or physical. For instance, a student's fear of going to school as a result of harassment may demonstrate emotional and academic harm to the student. Now, your private school may also be liable for fraud if it intentionally made false or misleading statements that convinced you to enroll. Examples may include deception about instruction, training, or graduation requirements. If you have any questions about a potential cause of action against a private school in Connecticut, please feel free to give me a call and I'd be happy to discuss your matter with you.
Attorney MacDonald is available 24/7 and can be reached by calling 203-221-3100. You can also email Attorney MacDonald at lmacdonald@mylaw.com, and please visit mylaw.com for more information.